211. The respondents admitted and stipulated that actual seizure or the laying on of hands is not necessary to constitute unlawful detention, and the only essential elements of an action for unlawful detention are 1. Detention or restraint against one's will, and 2. The unlawfulness of such detention or restraint. 212. The respondents admitted and stipulated that false imprisonment is akin to assault and battery imposed by force or threats affecting an unlawful restraint upon a man's liberty. 213. The respondents admitted and stipulated that any and every confinement of a man is an imprisonment. 214. The respondents admitted and stipulated that the term word false as used and employed in law does come from the common law, and is synonymous with unlawful, and a false arrest as one means of committing a false imprisonment. 215. The respondents admitted and stipulated that false imprisonment does exist by words or acts, or both, which one fears to disregard, and also does exist by such acts and measures that he cannot disregard. 216. The respondents admitted and stipulated that the unlawful arrest and detention of a man without lawful authority is one manner in which the category of those torts that unlawfully deprive or interfere with the liberty of a man termed false imprisonment is committed. 217. The respondents admitted and stipulated that false imprisonment is effectuated by the unlawful arrest or detention of a man without warrant, or by an illegal warrant, or a warrant illegally executed. 218. The respondents admitted and stipulated that the tort, or wrong, of false imprisonment does occur the instant that a man is restrained in the exercise of his liberty, and there is not a reasonable length of time for a restraint before the tort can be claimed. 219. The respondents admitted and stipulated that a man wronged by false imprisonment is entitled to recover damages for all the natural and probable consequences thereof for the whole of the time he was unlawfully, falsely imprisoned. 220. The respondents admitted and stipulated that false imprisonment does include an assault and battery, and does always, at least, include a technical assault. 221. The respondents admitted and stipulated that the law does specify or divide damages arising from torts for injury into two types or classes, and those two types or classes are actual damages and punitive damages. 222. The respondents admitted and stipulated that actual damages are compensation for the injury as would follow the nature and character of the act, which would include, inter alia, pain and suffering, physical discomfort, sense of shame, wrong, and outrage, and such damages are also termed compensatory damages as they compensate the injured man for the actual injuries sustained, and no more. 223. The respondents admitted and stipulated that punitive damages are those that grow out of the wantonness or atrocity, or aggravated thereby, of the act resulting in the injuries and sufferings that were intended, or occurred through malice, carelessness or negligence amounting to a wrong so reckless and wanton as to be without excuse, and such damages are also termed exemplary damages. 224. The respondents admitted and stipulated that anyone who assists or participates in an unlawful arrest and/or unlawful imprisonment, e.g. magistrate, justice of the peace, judge, United States Attorney or assistant, defense attorney, United States Attorney General, county prison superintendent, secretary of corrections, director of Federal Bureau of Prisons, warden and/or superintendent of the warehousing correctional institution, clerk, and city, county, state, federal, national government equivalents and the like, is equally liable for the damages arising from the injuries caused by said acts. 225. The respondents admitted and stipulated that actual or compensatory damages in actions, claims for false arrest, false imprisonment have been established at $25,000 per 23 minutes, $1,600,000 million per day, and punitive damages may be set by the injured party, and specifically the undersigned as the injured party within the above referenced alleged matter. 226. The respondents admitted and stipulated that Trezzavant v. City of Tampa can be utilized by the undersigned in determining actual, compensatory damages should respondents agree the undersigned has been falsely imprisoned and the respondents cannot provide any valid, lawful, and reasonable objection as to why it should not, or cannot, be so utilized and applied in this matter. 227. The respondents admitted and stipulated that the distinction between false imprisonment and malicious prosecution is the right in the former, which is even a guilty man has to be protected against any unlawful restraint of his personal liberty, and in the latter, the right of an innocent man to be compensated in damages for an injury he may sustain when a groundless charge is brought against him, even though such charge may be presented and prosecuted in accordance with the strictest forms of law. 228. The respondents admitted and stipulated that the aspects of malicious prosecution in a matter involving false imprisonment can be used in determining punitive damages in a false imprisonment action claim. 229. The respondents admitted and stipulated that the want of authority is an essential element in an action claim for false imprisonment, and malice and want of probable cause are the essential elements in an action claim for malicious prosecution. 230. The respondents admitted and stipulated that the defense for, against an action claim of false imprisonment is limited to showing that the arrest was pursuant to law, and the one arresting had lawful authority to so act. Thus, a valid defense against an action claim of false imprisonment is one asserting the legality and lawfulness of the arrest. 231. The respondents admitted and stipulated that the arrest of the undersigned in the above reference alleged matter was not for a lawful cause, i.e. for a crime, public offense created and established by validly enacted statute, law originating from the sole legislative power, authority as created by express constitutional provisions clearly identified as such upon its face and properly, validly, and lawfully promulgated, published, and was in a legal and lawful manner, i.e. pursuant to due process of the law as ordained by the law of the land through express constitutional provisions, and executed by those with lawful authority, i.e. lawfully holding, occupying their office and thereby in lawful possession and use of the powers resident therein. 232. The respondents admitted and stipulated that due to the high regards placed upon liberty by the law, all imprisonments are deemed unlawful until the contrary is shown, and a defense based upon the one who was arrested must prove the imprisonment was unlawful in order to prevail in any process for relief and remedy cannot be used. 233. The respondents admitted and stipulated that the only thing a man who has been arrested and imprisoned needs to claim and to prove is one of two things, which are, 1 the defendant made an arrest or imprisonment, or 2 the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. 234. The respondents admitted and stipulated that the undersigned has up to this point within this conditional acceptance for value for proof of claim established his arrest and imprisonment at the hands, and by the acts, of all parties participating within the above referenced alleged matter, and the unlawful, false nature of said arrest and imprisonment within said alleged matter. 235. The respondents admitted and stipulated that should the respondents agree, expressly or through tacit acquiescence, with the facts contained within this conditional acceptance for value for proof of claim, they are bound by their duty to correct this matter and provide relief and remedy to the undersigned in this matter without delay, i.e. releasing the undersigned's corpus and person, along with all property of the undersigneds from the bonds of false imprisonment, and restore the undersigned to a state of liberty, freedom of locomotion, full compensation as invoiced by notice, and completely expunging this matter from all criminal records, databases, files, and the like no matter how stored. 236. The respondents admitted and stipulated that the failure of respondents in exercising their duty in this matter as set forth above, does thereby, and therein, act to make respondents liable for the false arrest and false imprisonment of the undersigned resulting from the above referenced alleged matter, jointly and severally. 237. The respondents admitted and stipulated that it has been held and well established in law that in false imprisonment processes for relief and remedy the defendant, in order to escape liability, must prove that he did not imprison the man, or he must justify the imprisonment, or stated another way, the burden is upon the defendant to show that the arrest was by authority of law. 238. The respondents admitted and stipulated that in cases of false imprisonment, the only essential elements of the action claim for relief and remedy are detention and its unlawfulness, and that malice and the want of probable cause does not need to be shown, or are not necessary to a proper cause of action for false imprisonment. 239. The respondents admitted and stipulated that unlawful detention or imprisonment does not become lawful because it was out of ignorance of the law. 240. The respondents admitted and stipulated that whereas a magistrate, justice of the peace, judge, attorney, prosecuting, defense, and arresting officers are all schooled, trained, and licensed to practice law, some more than others, and specifically as this matter relates to and bears upon said parties acting within the above referenced alleged matter, and therefore have superior knowledge of the law, said parties, and the respondents, are not capable or justified in claiming ignorance of the lawfulness and legality of the arrest of the undersigned and subsequent imprisonment imprisonment resulting therefrom within said alleged matter, and such an assertion would thereby, and therein, operate to constitute said parties, and the respondents, as unqualified and or unfit to practice law, and at the very least, in need of additional schooling, training. 241. The respondents admitted and stipulated that in an action for false imprisonment, a record of conviction for the same offense for which the arrest was made is not admissible. 242. The respondents admitted and stipulated that in an action process for relief and remedy from false imprisonment such as to be based solely upon the legality of the arrest, and is not to be based upon the filing of some complaint, or the proof of an alleged crime, or the results of some trial. 243. The respondents admitted and stipulated that the argument of official immunity is not a valid defense for public government agents when proceeded against for their own torts in an action process for relief and remedy from a false imprisonment claim. 244. The respondents admitted and stipulated that under the doctrine of immunity there have been distinctions made between acts that are discretionary duties which one in the performance thereof is immune within, and acts which are ministerial duties which one in the performance thereof is liable for. 245. The respondents admitted and stipulated that a law enforcement officer's official duty is described as ministerial, when it is absolute, certain, and imperative, involving merely execution of a specific duty arising from fixed and designated facts, and the same can be said of the official duty of a magistrate, justice of the peace, judge, United States attorney or assistant, and an attorney general, and state of, and local equivalents, instrumentalities. 246. The respondents admitted and stipulated that the act of arresting a man by a law enforcement officer, however termed, styled, is a ministerial act, and is not a discretionary act. 247. The respondents admitted and stipulated that the due process of the law argument in false imprisonment matters will nullify the statutes, rules, regulations, ordinances, and the like as may be contained within the United States Code, and state of equivalents, instrumentalities, and elsewhere that are contrary to the common law rule on arrest, and a legislative act cannot abrogate what is the law of the land. 248. The respondents admitted and stipulated that a man confined by virtue of a void warrant, and thereupon imprisoned, is falsely imprisoned, and the complainant, the prosecuting attorney, magistrate, justice of the peace, and/or judge, who ordered said man to be committed, along with the arresting officer who executed said void warrant, the jailer, warden, superintendent and the like are all liable for false imprisonment. 249. The respondents admitted and stipulated that the Constitution for the United States of America C-1819, as the express document, instrument for the government of the original jurisdiction, does reference genuine law. 250. The respondents admitted and stipulated that there is a difference between what is lawful and what is legal, as such term, word is employed, used by the present-day civil authorities and their courts. 251. The respondents admitted and stipulated that lawful does mean in accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law, and is dealing with the spirit, i.e. the substance, content, object of law, and does properly imply a thing conformable to or enjoined by law. 252. The respondents admitted and stipulated that legal does pertain to the understanding, the exposition, the administration, the science, and the practice of law, as the legal profession, legal advice, legal blanks, newspaper, and the like. 253. The respondents admitted and stipulated that legal does mean implied or imputed in law, and as opposed to actual, i.e. express, what is real, substantial, existing presently in act, valid objective existence as opposed to that which is merely theoretical or possible. 254. The respondents admitted and stipulated that legal does look more to the letter of the law, i.e. form, appearance, and shadow of the law. 255. The respondents admitted and stipulated that legal is more appropriate for conformity with positive rules of law, and lawful is more appropriate for accord with ethical principles. 256. The respondents admitted and stipulated that legal does import rather the forms, appearances of law are observed, that the proceeding is correct in method, and rules prescribed, dictated, have been obeyed. 257. The respondents admitted and stipulated that lawful does import that the right is actual in substance, and that moral quality is secured. 258. The respondents admitted and stipulated that legal is the antithesis of equitable, and is the equivalent of constructive, i.e. that which has not the character assigned to it in its own essential nature, but acquires such character in consequence of the way in which it is regarded by a rule or policy of law, hence, inferred, implied, made out by legal interpretation. 259. The respondents admitted and stipulated that a writ or warrant of arrest issuing from any court, and specifically the alleged court of record within the above referenced alleged matter, under color of law, is a legal process and defective. 260. The respondents admitted and stipulated that legal matters do administrate, conform to, and follow rules, and is not equitable in nature, and is implied, i.e. presumed, rather than actual, i.e. express. 261. The respondents admitted and stipulated that a legal process can be defective in law, and the legal process within the above referenced alleged matter is defective in law. 262. The respondents admitted and stipulated that to be legal, a matter does not follow the law, and is not required to follow the law, and does not conform to and follow the rules or forms of law. 263. The respondents admitted and stipulated that lawful matters are ethically enjoined in the law of the land, the law of the people, and are actual in nature, they are not implied. 264. The respondents admitted and stipulated that the proper and truthful definition and meaning of the term word legal is color of law, i.e. the appearance or semblance of law, without the substance, or right. 265. The respondents admitted and stipulated that colorable does mean that which is in appearance only, and not in reality, what it purports to be, i.e. counterfeit, feigned, having the appearance only of truth. 266. The respondents admitted and stipulated that statutory jurisdiction is a colorable jurisdiction, created to enforce colorable contracts, and is legislative and administrative rather than judicial in nature, and does operate, function, exist to enforce commercial agreements based upon implied consent rather than contracts under the common law or the law of the land. 267. The respondents admitted and stipulated that public policy does equal government policy, which does equal corporate policy, which does equal commerce, which does equal Federal Reserve reinsurance policy, which does equal public credit, debt, which does equal commercial transactions of private enterprise, which does equal non-substance reinsurance script, Federal Reserve notes, a note being evidence of debt, which does function as money currency in a colorable equity, admiralty, maritime jurisdiction. 268. The respondents admitted and stipulated that a copyright symbol employed, used in the publication of written or recorded matter does act, operate to give notice that said printed, recorded matter is the private intellectual property out of the public domain of the copyright owner. 269. The respondents admitted and stipulated that a copyright symbol employed, used in publication of statute, law, books, codes as specifically employed, used in the printed publication of the United States Code, state of, and local equivalents, and or specifically the ACT of March 9, 1933 and any and all laws implemented based upon that alleged authority and foundation thereof, does act, operate to give notice to all that the contents therein is the private intellectual property of the copyright owner, and out of the public domain. 270. The respondents admitted and stipulated that a statute, law, book, code placed under copyright such as the United States Code, and state of, and local equivalents, and or specifically the ACT of March 9, 1933 and any and all laws implemented based upon that alleged authority and foundation thereof, is by virtue and operation of said copyright factually, substantially, and truthfully private law in support of a private right belonging to the copyright owner. 271. The respondents admitted and stipulated that the maxim of law, ignorance of the law is no excuse, does not apply to private law in support of a private right, and that any man, and specifically the undersigned as this relates to and bears upon the above referenced alleged matter, does not have any duty, obligation, or compelling need to know the private law in support of a private right of any man or person. 272. The respondents admitted and stipulated that genuine, actual, true law of the people cannot be copyrighted. 273. The respondents admitted and stipulated that any true public document of a de jure and de facto state or nation has not been, and cannot be under copyright, and as such are in the public domain. 274. The respondents admitted and stipulated that whereas all statute, law, books, codes of the federal and state governments are copyrighted, a man practicing law would require a letters patent to practice said law within the present-day courts, and said right to practice law is a property right existing by virtue of letters patent, and said patent is the so-called license an attorney holds out as possessing to would-be clients, and without said patent, said man would be doing that which would otherwise be illegal, a trespass, or a tort. 275. The respondents admitted and stipulated that whereas West Publishing Company holds out its firm as the copyright owner, the fact that said company is owned by the Thompson Group, LLC, Limited, a publishing interest of the Crown, does thereby, and therein, constitute and establish said statute, law, books, codes known as the United States Code, and state of equivalence, foreign-owned private law in support of a private right of the actual copyright owner, i.e. the Crown. Note, the Thompson Group owns, inter alia, West Publishing Company, Barclays West Group, Bancroft Whitney, Clark Boardman, Callahan, Legal Solixes, Rudder Group, Warren, Gorham and Lamont, Lawyers Co-op, Reed Elsevier owns, inter alia, Lexis, Deering Codes, rendering all such published law private, non-public domain, property of the Crown. 276. The respondents admitted and stipulated that a court of record is a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it, and does proceed according to the course of common law, and its acts and proceedings are enrolled, i.e. to register, to make a record, to enter on the rolls of a court, to transcribe, for a perpetual memorial. 277. The respondents admitted and stipulated that a court of record is the only court that possesses the power to fine or imprison, and courts not of record do not possess the power to fine or imprison. 278. The respondents admitted and stipulated that a de facto court is a court established, organized, and exercising its judicial functions under authority of a statute apparently valid, but which is in fact unconstitutional and afterwards so adjudged, and is a court which is established and acting under the authority of a de facto government. 279. The respondents admitted and stipulated that if a court is not a court of record, it does not have any power to fix and establish a penalty, i.e. a punishment established by law or authority for a criminal, public offense, and does not thereby, and therein, create any penological interest for others to claim, e.g. state and federal correctional institutions. 280. The respondents admitted and stipulated that prison and penitentiary are used synonymously. 281. The respondents admitted and stipulated that a prison or penitentiary is a place of confinement of men for the purpose of punishment. 282. The respondents admitted and stipulated that the word term correctional as used in state, federal correctional institution does mean discipline for the purpose of curing faults or bringing one into proper subjection. 283. The respondents admitted and stipulated that the word term institution does denote a public establishment, corporation, which is created and exists by statute or public authority such as an asylum, charity, college, university, schoolhouse, and the like. 284. The respondents admitted and stipulated that the alleged court of record within the above-referenced alleged matter was not, and is not, in fact established and functioning as a valid and lawful court of record which proceeds according to the course of common law, and whose acts and proceedings are not enrolled, and a court which does not have power to fine and imprison and thereby, and therein, not creating a penological interest of which may be claimed by the Department of Justice of the United States of America, and state of, and local equivalents, instrumentalities. 285. The respondents admitted and stipulated that there does not exist, this present day, any courts of records within the United States of America, state of, and local equivalents, instrumentalities. 286. The respondents admitted and stipulated that a court's power to punish by fine or imprisonment does ensue from a valid and lawfully enacted statutes, laws creating a real criminal, public offense, and such penal statutes, laws do not exist within the United States of America, state of, and local equivalents, instrumentalities, and the absence of such penal statutes, laws is one of the reasons which courts of record do not exist within the United States of America, state of, and local equivalents, instrumentalities, as said courts, and specifically the alleged court of record within the above-referenced alleged matter, is not proceeding according to the course of common law, but merely upon the forms, shadow of that which formerly existed in spirit, substance, content, and actuality, i.e. expressly. 287. The The respondents admitted and stipulated that prisons and penitentiaries do exist within the United States of America, state of, and local equivalents, instrumentalities, wherein such are not established for the purpose of punishment ensuing from valid and lawful penal statutes, laws, and which may not claim a penological interest in, and from, such statutes, laws. 288. The respondents admitted and stipulated that a penological interest does not exist for and within state, federal correctional institutions, and specifically all those which compose the Department of Justice, Federal Department of Corrections of the United States of America, state of, and local equivalents, instrumentalities, and such are functioning, operating as disciplinarian asylums for the purpose of treatment of presumed mental, emotional dysfunctions and re-indoctrination, programming to cure faults in the nature of social breaches in thought, action, behavior, and the like. 289. The respondents admitted and stipulated that the inability of courts today, and specifically the alleged court of record within the above referenced alleged matter, to punish is why the mental health laws were merged with the criminal process so as to allow the courts the ability to treat, and thereby confine those convicted, adjudged, i.e. in need thereof. 290. The respondents admitted and stipulated that the alleged court of record within the above referenced alleged matter was, and is, established, organized, and exercising its judicial functions under authority of a statute, and said statute is unconstitutional, and is established and acting under authority, e.g. authority derived from a foreign, non-constitutional source of authority of law, of a de facto government, i.e. a government not lawfully created, operating, functioning, and exercising its authority in accordance with and pursuant to the document of its creation which established and ordained the government for the United States of America, i.e. the original jurisdiction as opposed to the United States of America, and state of, and local equivalents, and was, and is, exercising its judicial functions and authority as a de facto court of said de facto government, authority. 291. The respondents admitted and stipulated that the United States of America, and state of, and local equivalents, are federal corporations. 292. The respondents admitted and stipulated that the United States of America is a municipal for-profit corporation originally incorporated February 21, 1871, under the name District of Columbia, and reorganized June 8, 1878, D.B.A. United States Government aka, DBA the United States of America, c. 16 Stat. 419, ch. 62, 41st Congress, 3rd Session, an Act to provide a government for the District of Columbia, 20 Stat. 102, ch. 180, 45th Congress, 2nd Session, an Act providing a permanent form of government for the District of Columbia. 293. The respondents admitted and stipulated that the United States of America, and state of, and local equivalents, is a corporate entity operating, functioning in commerce as a bankrupt in Chapter 11 reorganization wherein, and whereby, the federal, state government represented therein has been dissolved along with said corporation's sovereign authority, and the official capacities of all offices, officers, and departments, and said federal government does exist today in name only. See House Joint Resolution 192 of June 5, 1933, Pub. R. 73-10, Executive Orders 6072, 6102, 6111, and 6246. Senate Report 93-549, Cong. Rec. March 17, 1993, Volume 33, Speaker, James A. Trafficant, Jr., which states in part, Mr. Speaker. We are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization in world history, the U.S. government. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat. 1, Public Law 89-719, declared by President Roosevelt, being bankrupt and insolvent. H.J.R. 192, 73rd Congress in session June 5, 1933 Joint Resolution to suspend the gold standard and abrogate the gold clause, dissolved the sovereign authority of all United States and the official capacities of all United States government offices, officers, and departments and is further evidence that the United States federal government exists today in name only. 294. The respondents admitted and stipulated that this new municipal corporation D, B, A, the United States of America, and state of, and local equivalents, did adopt the original organic constitution for the United States of America C-1819 as its corporate municipal charter. See, 41st Congress's Acts, Session 3, ch. 62, p. 419, Sec. 34, February 21, 1871. 295. The respondents admitted and stipulated that the location of the United States of America, and state of, and local equivalents, is in the District of Columbia. See, UCC 9-307 H, which states, location of United States is located in the District of Columbia, cf. Title 28 D.C. Code Section 28.9-307 H. 296. The respondents admitted and stipulated that this government for the District of Columbia was abolished by Act of June 20, 1874, and a temporary government by commissioners was thereby created and existed until the Act of June 11, 1878, wherein provision was made for the continuance of the District of Columbia as a municipal corporation controlled by the federal government through these commissioners, and said corporation is subject to the ordinary rules that govern the law of procedure between private persons. See, U.S. Reverend Stat. 1 Sup. 22, 7 D.C. 178, 132 U.S. 1, which states, the sovereign power is lodged in the government of the United States, and not the corporation of the district. 297. The respondents admitted and stipulated that the term United States as used and employed within the Constitution for the United States of America C-1819 at Article 3 Section 3, is used in the plural, i.e. them, their, and does mean none other than the people of the several states and not the national government situated within the 10-mile square of the District of Columbia, its enclaves, forts, magazines, docks, and arsenals scattered abroad, under, and only under, said Constitution establishing and ordaining the original jurisdiction and the government for same. 298. The respondents admitted and stipulated that the term, word, state does mean a state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory or insular possession subject to the jurisdiction of the United States. See, UCC 9-102 76, cf. Title 28 D.C. Code Section 28.9-102 76, and a state of the United States is not inclusive of the 50 freely associated compact states, i.e. the several states, but a state of the United States is a corporate or corporately colored sub-franchise territorial state unit of the parent corporation, i.e. the United States of America. 299. The respondents admitted and stipulated that the term in this state, this state, and state as employed, used within federal and state statutes, laws, ordinances, regulations, codes, and the like, and as this relates to and bears upon the United States Code, state of, and local equivalents, and all titles thereof, and the two capital-letter federal postal designation, e.g. AL, GA, KY and NY, and the 5-digit ZIP, i.e. Zoning Improvement Plan, Code are not references to, and are not inclusive of the freely associated compact union states, i.e. the several states, and are rather terms, designations, and codes defining and referencing federal zones, territorial state units, and are defined for tax jurisdiction purposes as the District of Columbia, i.e. the United States of America. 300. The respondents admitted and stipulated that the District of Columbia and the Territorial District of the United States of America are not states within the meaning of the Constitution for the United States of America C-1819 and the Judiciary Act so as to enable a citizen thereof to sue a citizen of one of the states in federal courts, and are not states as that word is used in treaties with foreign powers, with respect to the ownership, disposition, and inheritance of property. 301. The respondents admitted and stipulated that if a nation comes down from its position of sovereignty and enters the domain of commerce, it does submit itself to the same laws that govern individuals therein, and does assume the position of an ordinary citizen therein, and cannot recede from the fulfillment of its obligations therein. 302. The respondents admitted and stipulated that the United States did stipulate to becoming territorial state units of the United States for receipt of benefits through the Social Security Act of 1935. 303. The respondents admitted and stipulated that the several Union states did accommodate the federal bankruptcy through pledge of its faith and credit to the aid thereof at the Conference of Governors, March 6, 1933. See Declaration of Interdependence, January 22, 1937, Book of the States, Volume 2, p. 144. 304. The respondents admitted and stipulated that the walkout of the seven Southern nation-states from Congress March 27, 1861, without setting a day to reconvene or a vote of adjournment, thereby leaving Congress without a quorum, did dissolve the de jure and/or de facto Congress of the United States of America, to which President Lincoln responded with force, reconvening Congress within a private military jurisdiction under martial law in his capacity as Commander-in-Chief, and said Congress does, and is, operating, functioning in the same capacity, and under the same authority, to this present day. 305. The respondents admitted and stipulated that the post-Civil War revisions of the constitutions of the freely associated compact Union states, i.e. the several states, such said revision of any state did alter said instrument specifically in one important area, i.e. abolishing the entire class of free electors and replacing them with the elective franchise registered voters in compliance with the public trust, i.e. the Sestuike trust, i.e. a constructive trust, i.e. a trust which is a mixture of law and not or fraud as established within and under the purview of the 14th Amendment to the Federal Corporate Parents' Charter, Constitution formerly adopted, or so alleged, February 27, 1871, thereby, and therein, extending said public trust to operate within the several states. And said revisions of said constitutions did thereby, and therein, dissolve the General Assemblies as originally established and ordained, of all the states, and such did place these General Assemblies upon the same footing and within the same jurisdiction as that of the Congress wherein, and whereby, their constitutional identity as constitutionally created entities by law was lost, and did cause same to lose all lawful right, authority, and power to legislate upon any and all subjects for the people of the several states, which did cause the post-Civil War revisions of all the statutes, laws into codes which did act to remove the law and leave merely the form, shadow of same, i.e. the legal aspects standing. 306. The respondents admitted and stipulated that the revisions of the state constitutions as originally established and ordained, upon cessation of open hostilities of the Civil War in which were destroyed the entire class of sovereign electors and replaced by registered voters. The elective franchise, such did destroy sole proprietorships or principal creditorships of, by, and for the people, and did replace them with artificial corporate franchises under purview of the 14th Amendment to the Federal Corporate Municipal for Profit Parent Government's Charter, Constitution. 307. The respondents admitted and stipulated that under the instrumentality rule, the United States of America is, and will be responsible when the subservient corporation becomes exposed as a mere instrument and actually indistinct from the controlling corporation, i.e. the United States of America, and state of equivalence, also known by any and all derivatives and variations in the spelling of said names, is operating and functioning as a mere corporate instrument, sub-franchise compact territorial corporate state unit of the United States of America. 308. The respondents admitted and stipulated that the doctrine of equal standing in law and the maxim of law, disparata non debent jungi, dissimilar things ought not to be joined, does make it perfectly clear that only parties of equal standing can communicate in law. 309. The respondents admitted and stipulated that a judgment is void for uncertainty if it fails to identify the parties for, and against, whom it is rendered with such certainty that it may be readily enforced. 310. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is a corporate franchise, and or sestuike vi, and or constructive trust, and or estate, and or the like. 311. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is an item sonans, i.e. sounding the same or alike, as with the name of the undersigned. 312. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter does represent, and is, a legal name, i.e. the name of the legal person recognized in law. 313. The respondents admitted and stipulated that a legal name, as this relates to and bears upon the named alleged defendant within the above-referenced alleged matter, is a name constructed upon the form and shadow of true name, but without the substance, value, spirit, essence, and the like, and legal names are the only names recognized, and capable of being recognized, in law today, and do denote, identify, and reference artificial persons. 314. The respondents admitted and stipulated that a legal name, and specifically as this relates to and bears upon the named alleged in the above referenced alleged matter, is written in legalese, i.e. a language foreign to, and constructed outside of, the bounds of English grammar. 315. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is a juristic person, i.e. a person, i.e. an artificial person, i.e. a legal person, i.e. an entity, such as a corporation, created by law, birth registration acts of the various corporate sub-franchise compact territorial state units, and given certain legal rights, grants, benefit, privileges, and duties of a being, real or imaginary, who for the purpose of legal reasoning is treated more or less as a man, and also termed a fictitious person, juristic person, and legal person. 316. The respondents admitted and stipulated that the term in propria persona, i.e. in one's own person, does tacitly, and expressly, declare and affirm that there is some other person by whom and through whom one can, may act, and such other person is a corporate person persona. 317. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter does exist only by force of or in contemplation of law, i.e. solely within the imagination having no actual existence. 318. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is a dummy, i.e. a sham, make-believe, pretended, imitation, straw man, a man who serves in place of another, or who serves until the proper person is named or available to take its place, e.g. as in dummy corporate officers, dummy owners of real estate, and when its name is called in court and specifically as this relates to and bears upon the named alleged defendant within the above-referenced alleged matter, and a living, breathing flesh and blood real man, e.g. the undersigned, answers believing said name to be his own true name, said proper person is thus found, available, and thereby, and therein, joined, without notion albeit through fraud. 319. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is a dummy corporation, i.e. a corporation formed for sham purposes and not for conducting legitimate business, e.g. to avoid personal liability, and as this relates to and bears upon the above-referenced alleged matter, to establish the obligation for payment of fines, fees, and specific performance as that of the undersigns as an accommodation party, and surety for the principal, i.e. the all-capital letter named alleged defendant in said alleged matter. 320. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is an ens legis, i.e. a creature of the law, an artificial being, as contrasted with flesh and blood, real, sentient man, such as the undersigned, applied to corporations, and considered as deriving their existence entirely from the law. 321. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is a fictitious name, i.e. a counterfeit, feigned, or pretended name, differing in some particular essential from a man's true name, with the implication that it is meant to deceive or mislead, consisting of a Christian name and patronymic name of the house, father, family, surname. 322. The respondents admitted and stipulated that a fictitious name is the opposite of a true name of a man, e.g. the underside's true name as shown herein below, and said fictitious name is created by public policy of the corporate the United States of America, and state of, and local equivalents, at the time of a man's birth and brought wholly into separate existence via the man's birth record, document, instrument thereby, and therein christening said corporate franchise as a commercial vessel under the United States of America, state of, and local equivalents registry. 323. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is an individual as such word, term is used, employed in state and federal statutes, laws, codes, and is defined as a citizen of the United States, and said definition is a reference to the 14th Amendment of the corporate the United States of America Charter, Constitution, and said reference does denote said named individual as that of a trust entity. See Title 5 U.S.C., Section 552a 2. 324. The respondents admitted and stipulated that where a federal definition of a term, word exists and is provided, such definition does supersede any and all definitions given for the same term, word within the sub-franchise compact territorial state units aka state of, and local equivalents. 325. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is a legal fiction, i.e. something assumed to pretend, to accept without proof, an assumption created by the imagination which, without that irksome necessity for proof, allows for truth to be a lie, and a lie to be the truth, establishing essentially the doctrine of pretending, based on pretense, lies, deceit, and dissembling, i.e. to conceal or disguise the true nature of so as to deceive, and to conceal one's true nature, i.e. to act hypocritically. 326. The respondents admitted and stipulated that recognized in law as applied to these legal names of legal persons and employed, used within the courts, and specifically the alleged court of record within the above-referenced alleged matter, and legal system today does mean existing by force of or in contemplation of law. 327. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter does reference and identify a public vessel, i.e. one owned and used by a nation or government for its public service, e.g. within its revenue service. 328. The respondents admitted and stipulated that public is the vast multitude, which includes the ignorant, the unthinking, and the credulous, and does reference and identify only artificial persons which possess no brain nor intelligence, and the public of the United States of America, state of, and local equivalents, is comprised solely of such artificial persons, and public law, policy, the United States of America, state of, and local, does operate solely upon said persons. 329. The respondents admitted and stipulated that a vessel in admiralty law is limited to ships or vessels engaged in commerce, and in admiralty the names of vessels are designated in all-capital letter format, style, and the all-capital letter named alleged defendant in the above-referenced alleged matter does represent and identify a vessel in admiralty in which all jurisdiction ensues, flows, and arises from contract, real or presumed, expressed or implied, revealed or unrevealed. 330. The respondents admitted and stipulated that the all-capital letter named alleged defendant in the above-referenced alleged matter is referencing and identifying a straw man, straminius homo, i.e. an artificial person created by law having a fictitious name, existing only by force of or in contemplation of law, a distinct legal entity corporate that benefits the creator, i.e. the United States of America, and state of, and local equivalents, allowing the creator to accomplish things in the name of the straw man that would not otherwise be permitted. 331. The respondents admitted and stipulated that the word, term, transmit does mean to convey, send, transfer, or to pass along as used and employed within the current present-day legal profession and courts.